Hi everyone, it's Deb Fuster from VCOSS, and it's my pleasure to welcome you back to another Renters' Rights Rundown event. We have Ben Cording here from Tenants Victoria, back by popular demand. Ben is here to answer all the questions that we couldn't get to at our March Renters' Rights event. So thank you, Ben. We know that community sector workers play a really crucial role in helping renters to know their rights, understand their rights, and assert their rights. So we're really pleased to help you out with the information that you need to confidently advise and refer renters. As always, big thanks to the Victorian Government through the Victorian Property Fund in supporting us to bring these information resources to you. And without further ado, I'm going to hand over to Ben. Thank you, Ben.
Okay, let's get into it. We've got some questions here from people. It says, what is the best way to advise and support a renter when they have a strained relationship with their landlord and they have no confidence to deal with them directly? It's a really great question that's being asked, and there's a lot of recognition that everyone's different, but understanding what it means to be client-centred and understanding what it means to be trauma-informed are really good places to start. When we say client-centred, what we're really asking is about what matters to this renter, what's going on in their life. So sometimes you might come with repairs, or there might be a really simple issue, but actually it could be that every time it comes to dinner time, all the kids are getting frustrated, everyone's getting ratty, or in winter, people are cold. There's really some important factors that we need to understand what's causing the strain on the relationship. Naturally, people that are in hard situations are going to need to vent and project that stress. And so if the landlord's in control of that, naturally people are going to get grumpy. And so we need to be self-aware about our own triggers. We need to be self-aware about how we communicate and help our clients understand that. I know that this is important for you. And sometimes a really great place is to start with empathy. What does it look like for me? What does it look like for the landlord? What's going on for them? A lot of the time we have conflict, it's usually about a conflict of values. It might be money, and I'm trying to look after my children. And what we want to do is open up a dialogue that's not necessarily always going to be emotional, but recognise what matters for both parties. So if we do have those relationships, sometimes through good communication we can resolve it. Sometimes there are parties that only care about money, that only care about if the rent's paid. And if that's the case, you need to be aware of what your rights are. And often, to deal with stress, what we want to do is find out what our rights are so we know what are our options. I want you to fix it within a week. If you don't fix it in a week, I'm going to go to VCAT. I'm going to get into VCAT, and I know I can get there within 2 days. So when we talk about confidence, it's a really difficult thing for a lot of people when there's a housing crisis going on. The Law Foundation has done a huge amount of work around the public understanding of law, and this is really asking the question about how various people in our communities feel confident to engage the legal system, and when they don't, and what we can do to support them. What does it mean for me as an adult with schizophrenia and 3 children to go through a justice system where I might have had other events in my life that have been really confronting? So do I understand that, and how do I build the confidence? In fact, in a lot of VCAT hearings, you can go in the back of the room and sit and listen and see someone else's hearing and go, okay, I know I can do that. For a lot of renters, I tell them it's a little bit like Judge Judy. There's a big table, one person sits this side, one person sits that side, and the person at the front is called a member. And so us understanding what we're going to go through can help relieve some of that tension and anxiety about using that justice system. But we do know that there are people out there that really do need support. So if you go to VCAT, you can have a support person. That's fine. Everyone needs some support. It can be really scary. But when they succeed, that's how we build confidence. When people share their stories, that's how we build confidence to make sure that the landlords that aren't doing the right thing are brought to account, and that for the landlords that actually may not fully understand what's going on, or their agent isn't giving them all the story, that you can have a better relationship, and that people can actually recognise that when you provide a home, you're providing an essential service, a place that should be safe, a place that is an asset for the landlord, but primarily it's something that is part of what we consider absolutely necessary for our society and community to function in a really healthy way. So that's one question. Next one, tricky one. Unfortunately, there are still cases in which family violence matters are delayed at VCAT. Can a member terminate a lease retrospectively, or can it come into effect on the actual date of the hearing? So I think what's being asked here is that sometimes we have someone that's experienced family violence and they just leave. They just want to go. Completely understandable response. It's probably taken a huge amount of energy to get to that point and decision. And hopefully, you engage the supports you need, because it's a really it's a high risk time when someone's planning to flee their property. When it comes to how the agreement's ended, there are different circumstances. So in most cases, we would encourage people to go onto the Tenants Victoria website and check out our family violence kit. And what that tells us is that when someone applies to either put the tenancy in their name or to end the tenancy because of family violence, that needs to be listed within 3 business days or the next available date. And so it should be pretty quick. We are hearing that there are some delays beyond that time, which is pretty concerning. Family violence have got, also VCAT's got a family violence worker, a dedicated worker who's fantastic, and that might be a good place to start if you're experiencing delay. But the question about whether or not the tribunal, VCAT, will go back in time and say, well, yes, I recognise that you left on the 1st of June, but we're now at a hearing, the end of September. What's the liability? It will depend on the circumstances, but usually VCAT is pretty reluctant to backdate liability. What can be done is if you make an application in relation to family violence, specifically under Section 91V of the Residential Tenancy Act, the tribunal can apportion liabilities. And when we talk about apportionment, that means that if me and the person using violence are both on the list, the tribunal can say, well, I do recognise that you left in June, and so I'm not going to make you liable for any of the rent arrears that accrued after that date. Or I recognise that there's been damage to the property. I'm not going to make you liable for that because I can see it's been done in the course of family violence. So there are a number of discretions that the tribunal has about making the user of family violence liable if they're on the rental agreement. If they're not on the rental agreement, for example, if there's a stalker or there's someone actually that lives in the property but they're not on the lease, it is a more difficult situation to do that adjustment. So if the person wants to leave, they can give their 28 days notice and leave, or if they need to leave immediately, they can give the keys back and say, look, I'm leaving for these reasons. And they can raise the issue of not giving the 28 days with the tribunal to say, well, if I stayed, I would have been in a really high-risk situation. And the tribunal can now take that into account under Section 211A. So that hardship of whether you choose to stay or go is important, but it's usually best for victim survivors that have experienced family violence to make the application positively within VCAT, to VCAT. And then VCAT can make any of those adjustments. You previously needed to have an intervention order, a family violence intervention order. You don't need that anymore, but would really encourage anyone that is experiencing family violence to at least get the advice. We know for some people, they recognise the intervention order is really useful. For other people, they're really concerned that if they do that, there might be adverse actions. So it's up to everyone to decide what's best, but it's always good to get advice as a starting point. So hopefully that gives you a bit of guidance. Again, check out the family violence kit on the Tenants Victoria website. The next one we've got is, what's the best way to support a renter with urgent repairs during holiday periods? Holiday periods can be really tricky. Real estate agents go away, over New Year's and Christmas, and, how do I return my keys, and the number of other things that can happen. Whenever you start a rental agreement, you should be given an emergency contact number that should be answered at pretty much any time. That's why it's an emergency contact number. During the holiday periods, there's really no exception to that. There's no carve-out that says, during the holiday periods you can't get onto it. There is a process for renters to be able to pay for their own urgent repairs, up to $2,500 GST inclusive. We generally don't encourage renters to use that mechanism. So you'd spend the money and then you'd give them the notice, the quotes about how much it costs to get done. And provided that it is an urgent repair under the law, you can seek reimbursement. So you say, I spent this money, you got 7 days to pay me. If not, I'm going to go to VCAT, and you get an order for reimbursement, possibly offset against your rent. That's an option. But we generally encourage people to go to VCAT rather than chasing money. It's a lot easier in most cases. So during the holiday period, it shouldn't matter too much, but obviously safety is paramount. So if you've got a big gas leak, you probably want to jump onto that straight away, and also check whether or not it's infrastructure, like the gas meter or anything outside of the water meter, where it might not be your landlord's responsibility. So usually your electricity and water company are responsible up to and including the meter, if that's relevant. So the holiday periods, one of the other things is to try and get onto it straight away. So if you've got an urgent repair and you're aware of it before, or the holiday period's coming up, you may want to sort of make sure you've got a bit of a deadline and enough of a buffer so you can get into VCAT if you need to before the holiday period. That's fine. This one, regarding a SIL. So a SIL is a supported independent living housing. That's a accommodation which is usually bundled as part of getting accommodation and services within the NDIS in the disability sector. The accommodation is often what's called a specialist disability accommodation. It's under Part 12A of the Residential Tenancy Act. It moved over into the Residential Tenancy Act from the Disability Act probably about 5 years ago. And the question here is there a particular formula to work out the reasonable rent amount charged for each tenant to cover board and food? Probably one of the most important things to understand with SIL agreements and accommodation providers, where the accommodation provider is also providing services, is that they are two separate contracts. So you have one accommodation which is for where you live, your house. You've got exclusive possession of either the part of the house or a room, or it might be a whole house, and you've got services going on. And then you've got the actual SIL contract. And what's really important is that you can't force those contracts to be all bundled up into a single contract to say that if I want to get rid of my SIL, I also get evicted. They're two separate ones, which means that if I'm living in this place and I don't like my SIL provider, I choose to end that contract, I can do that. And everything else about my accommodation is still covered by the Residential Tenancy Act. They still have to give me a notice to vacate if they want to get me out. So it's really important that when we talk about covering board and food, that there are services that can be provided, but it's really important to recognise what's accommodation and what's actually getting the supports that might form part of my NDIS plan. So if people are experiencing issues around that space, Villa Manta, Mental Health Legal Centre and Tenants Victoria, they're definitely good places to start to have a conversation with and to try and understand. So we don't want to see people forced into a contract where that if you get your accommodation, you have to stay with that SIL provider for the duration of your accommodation. I wouldn't think that that's a lawful thing to be done. So it's a relatively new industry in that way, and so we want to make sure that people are being given fair contracts with fair terms, and that there's a real balancing of the power in those negotiations when people are starting to go into those accommodations and agreements.